you may know of a report by the government of the province of Ontario in 2004. And the objective, and I quote again, was to provide advice and recommendations about the use of private arbitration to resolve family and inheritance cases and the impact that the use of arbitration may have on people who may be vulnerable, including women, persons with disabilities, and elderly persons, and consideration of religious-based arbitrations, end of quote. This report followed a private group's plan to offer Islamic family arbitration to Muslims. Both the commissioning of the report and the completed report were taken by many to signal the introduction of Sharia law on a par with Canada's law. It sparked an outcry, not only in Canada, but in Europe as well. And in an about face, Ontario's Attorney General, similar to what we've heard here already, the reaction of politicians has been in other places. He then introduced amending legislation at to Ontario's Arbitration Act of 1991, banning all faith-based arbitration. NS trails a lengthy string of Canadian precedents. A quick survey adduces the following examples. For instance, in Alberta versus Hatarian Brethren of Wilson Colony in 1909, here a presumed clash between freedom of religious expression and public safety emerged from a regulation mandating the applicability of a personalized driver's license photo also to the reclusive Hutterite community in Alberta. They didn't want to get a photo made of themselves and didn't want to have it displayed on their driver's license. It was ultimately dismissed by the Supreme Court for, and I quote, absolute safety is probably impossible in a democratic society, end of quote. In Church of the Universe of 2011, the Ontario Superior Court summarily rejected the believer's claim to a religious right to smoke marijuana. The ruling said, and I quote, anti-pot laws have not usurped the constitutional religious freedom guarantees, end of quote. The polygamy reference in 2011 came to the Supreme Court of British Columbia and examined whether harm to liberty and security of the person and the vulnerable in society, notably children and women, was attributable to a religious polygamous arrangement. And this was a Christian religious arrangement, not a Muslim one. The associated protected rights were found to outweigh the right to polygamy and by extension to religious freedom. This is distinguished from the Supreme Court of Canada case in the Kirpan case in 2006. This ruling dealt with safety concerns surrounding the Indian Sikh practice of wearing a dagger amenable to, and it said that it was amenable to accommodation by encasing the dagger in a sheath, in a cover, and it had to do with children's right to wear the kirpan, the dagger, to school. Notwithstanding, the Quebec National Assembly went on to unanimously ban the religious symbol from provincial public premises. A cursory cross-country survey of attitudes concerning reconciliation of religion and multiculturalism shows that in Alberta and Quebec, concern about the community's collective identity is more pronounced than worry about harm caused to the individual person. Perhaps the fiercest debate on the subject in Canada took place in Quebec. There, the Bouchard and Taylor Commission on the Reasonable Accommodation, which some of you may be familiar with, looked into issues of freedom of religion in Quebec and concluded with a report comprising of 37 recommendations, suggesting, amongst others, that the government, the federal government, prepare an official white paper on secularism, on laïcité, but nothing has been done so far in this regard. So when we look at the history of legislation and jurisprudence, we see that public safety, the protection of women and children, collective identity, equal treatment of vulnerable communities, equality of freedom of expression, and so on, represent merely symptoms of a fundamental and essential, quote, truth, unquote, trapped in an epistemological conundrum. And in this conundrum, religious faith plays a very important role. The irreconcilability of reason, upon which a secular system is based, and faith, relentlessly resurfaces across a wide spectrum of case law, legislation, and public debate, at times prompting different, even contradictory approaches to the management of the friction and the interpretation of multiculturalism. And this brings me to address yet another aspect of the dynamics of multiculturalism, namely, very briefly, the establishment by the Department of Foreign Affairs and International Trade of the Office of Religious Freedom. This was announced in the fall of 2011, but has not yet been unveiled due to, surprise, surprise, the difficulty in finding the appropriate person to head this office. So it is due to be unveiled any day, but and maybe it was, I haven't been in Canada and haven't followed the news since last Thursday. Maybe there is no head for the Office of Religious Freedom. The purpose of the office is, and I quote, to promote and protect across the world, that is said somewhere later in the same statement, to promote and protect the freedom of religion and belief consistent with core Canadian values such as freedom, democracy, human rights, and the rule of law. It serves to show that religion, as I mentioned before, has become an important factor of consideration for the Canadian government and its foreign policy, prompted by the demographic changes within Canada, as well as conditions abroad, and the change also of government in Canada. A similar office was established in the 1990s in the United States, but was criticized for chiefly protecting and promoting Christianity overseas, and this is one of the reasons that the Canadian initiative has met with skepticism. I now come to summary and conclusion. At the beginning of the presentation, I argued that religion may represent the tallest hurdle yet for Canada to reconcile within its multicultural policy. Section 2A of the Canadian Charter of Rights and Freedoms posits religion, along with conscience, as first among other enumerated fundamental freedoms of a different ontological source. At the same time, it lists freedom of belief as cohabiting with the likes of freedom of the press and other media communications. So if I read to you section 2, it says everyone has the following fundamental freedoms. A, freedom of conscience and religion. B, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. C, freedom of peaceful assembly. And D, freedom of association, end of quote. The Equality Rights section, section 15.1, adds a protective overlay to religious freedom. It specifically distinguishes the prohibition of religious as well as other forms of discrimination. And it reads as follows: every individual is equal before and under the law and has a right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability, end of quote. So both articles, 2A and 15.1, can be, are the pillars of equality and freedom in Canada, but they can be overridden in two ways. First, they can be overridden by being subjected to Section 1. And Section 1 reads, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in its in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society, end of quote. And then there is section 33.1, which is known as the notwithstanding clause, authorizing that, and I quote, Parliament or the legislature of a province may expressly declare that the act or a provision thereof shall operate notwithstanding a provision included in section 2 or section 7 to 15 of this charter, end of quote, which are the sections of religious equality and freedom. I come back to close the presentation by telling you what were the arguments put forward in the NS case to the Supreme Court of Canada. The applicant, the complainant, argues, and I quote, she should be entitled to wear the niqab out of respect for her charter religious freedom and equality rights, respect for her dignity and vulnerable position as a sex assault complainant, and because the veil does not impair a full assessment of her reliability. And that became the last part, the main part, the pillar of her argument that went from the preliminary hearing up to the Supreme Court of Canada. The respondents maintains in their factum that, and I quote, the establishment of open and secular courts is a core value of Canadian democracy, where the ability of trial courts to observe the witness is also one of the foundations of appellate deference to findings of fact. And end of quote. Now, there has been another respondent to this case, and this is the respondent Attorney General for the province of Ontario. And that respondent seeks to uphold the appellate court's approach, which consists of a use of what the court called constructive compromise, which, and I quote again, is critical to the available to mitigate the possible impact on a witness' right to exercise her religious beliefs and an accused's right to a fair trial, end of quote. So for the time being, the anticipation for the Supreme Court of Canada judgment settling this conflict of rights serves to keep the discourse on the place of religion within Canadian multiculturalism, or within the Canadian multicultural mosaic, at bay. There is not much happening in this regard in the media, and people do not discuss it. It is almost as forgotten, although we don't know what the judgment is and whether a judgment ruling has been made. Should the judgment be made public, the question arises, in what way is it, on the one hand, informed by, and on the other hand, poised to enhance the multicultural heritage of Canada? What will the Office of Religious Freedom have to convey to other countries struggling with similar conflicts involving protected rights and democratic institutions? And finally, and if the judgment is reserved, how will Canadian courts adjudicate should a similar case arise in the future? All this remains to be seen. Thank you for your attention.